A very warm good afternoon to all of you. In the morning we had webcast on advanced tax laws and practice for professional program. And now those who have missed out need not to worry because the same will be uploaded on the YouTube shortly. Now we will held a webcast on drafting appearances pleading, and today we have with us Mr. S. Narayanan, who is a visiting faculty with NRC. He has a vast experience of 24 years of experience. He is a visiting faculty in NRC for the last 24 years, and he will take up queries on drafting, appearances and pleading for both old and new syllabus as well. And again, I would like to remind you that tomorrow we will have this webcast on company law and tax laws and practice. And in between we have a special session on examination related queries from 12:10 to 12:14 noon. So please stay in tune with us. Now I will hand over the session to Mr. S. Narayanan.
Thank you. Good afternoon, friends. We are taking up the subject of drafting, appearance and pleading. Before I start the subject, my best wishes to all of you for this examination. You will be doing wonderfully well. Just have confidence. I am going to talk to you about certain tips. First thing I want to tell you that this subject is not difficult at all. We have to focus on certain things, certain methods of preparation, certain methods of writing. Then everything will be all right. Now, first thing I will say, it is drafting, appearance and pleadings. If you want to understand the concept of it, the first part is drafting, the second aspect will be pleading, the third aspect will be appearances. So first we will be discussing, that is we are supposed to discuss about how do we draft various agreements. First thing you have to understand that there is no law in India as to how to draft agreements. This is the first thing we have to know. Therefore, by any chance, you do not prepare it properly, even in your professional life, it is not going to affect you, but it will only affect the reputation of yourself and the institute. Therefore, there is a method in which, for example, I am telling you, I am going to sell you my house. I can't make the agreement buyer's name first, seller's name afterwards. Legally it may be valid, but it doesn't make sense. Because we are supposed to have the seller's name first, then the buyer's name. Like that, for drafting, there is no law as to how to draft. All we are going to do is, there are certain basic steps which you should know as to how to draft various kinds of agreements, other things. Then we come to the pleading aspect. Pleading actually refers to when the matter is being taken up before the tribunal or before the court. I go there, submit my problem there, and the other party gives the reply. Basically, as per law, only these two are called as pleadings. The plaint or petition and written statement combined together, it is called pleadings. I am making a pleading before the court or the tribunal. The third aspect is appearances. After making the pleading, the court fixes the date. I am supposed to go there, supposed to argue out what am I supposed to do at that time. Right from my dress code, everything will be covered. And the last chapter of our syllabus covers the consent orders and compounding of offences. This is one aspect. Now, making your examination easy, the preparation easy. First thing we have to understand, our syllabus has not been divided into part A, part B, part C and all. All chapters put together, there will be one question paper. So there is no need that you have to attempt 2 out of 3, all those things. You are supposed to attempt whatever be the questions that are asked there. So for preparation, it may be from the last chapter also, it may be from any chapter also. So when you go for preparation, the last chapter is the easiest chapter. The compounding of offence and consent orders is the easiest of the chapters. So what I am planning to do in this next, maybe 1 or 2 hours is that in each chapter, there are some important aspects. Please keep your studies with you. I am going to give you the page numbers also for old syllabus as well as new syllabus. When I tell the page number, just open it. I will give you the important aspects. First thing, it is importance as far as the past exams are concerned and from my point of view. But it is not sufficient for you to study only the important aspects. Take the important and also go for other things. This is one thing. Then, how do you write the exam? That also matters in getting the marks. Particularly for drafting, there is a method. As I told you, even though there is no law, there is a method we will be discussing at length as to what should come first, which should be in capital letters, executed at, executed on, various things. We will see one by one. That will take 15 to 20 minutes at least. But when you answer your questions in the examination hall, See, one type of question will be case studies. I will suggest one particular method for case studies. You are likely to get some 2-3 cases. I will tell you one particular method, how to attempt case studies. It will be of immense help to you if you are able to follow it. If you are not able to follow also, nothing wrong, but this is a better way of doing it. I will suggest. See, for example, let us say I am giving you a case now. A partnership firm, let us say, is unregistered. The firm has supplied goods to some people. They have not made the payment. The firm goes to court. The court says you are not registered, therefore we will not allow your petition. Because as per section 16 of the Partnership Act 1932, it is a disability for an unregistered firm. So what happens? The firm comes up. It goes for registration now. Again it goes to court. Now will the suit be admitted or not? This is the question. Now, one thing you have to understand at professional level, that sometimes the question may be from somewhat other acts than what is covered in this syllabus, this particular drafting, but it may be covered under various other laws. We must be prepared for everything. Now coming to this particular question covers 2 laws. One is Partnership Act and the other one is CPC. We are supposed to know both. So how you can answer? One way of answering is, yes, the firm can proceed, the suit will be admitted. This is one way of answering. Or the suit will not be admitted because you can give the reasons. What can be the problem in this? By any chance, if my answer is wrong, what happens? Even though I might have given the normal legal principles properly, but my answer is wrong. Therefore, naturally, I will not get any marks. The other method is simply write one paragraph. In between, you write there, yes, it's liable or what. That is also not proper because you don't expect the other party to go through thoroughly to find out where have you written the correct answer. So I tried to follow some other method when I was doing CS, LLB and all, which has been very handy for me, which I am planning to suggest to you. Think about it. If you want to use, you can use it. First, you write first paragraph, facts of the case. There, you reproduce the case in your own words. For example, X and Sons, a partnership firm is not registered. Make it in simple language. And then write that towards the end. The question now is, after getting registration subsequently, can they move the court or not? Now in this you write the facts of the case. Make a subheading, underline. The second part you come to applicable law. This question covers 2 laws, Indian Partnership Act 1932 and CPC 1908. As per Indian Partnership Act 1932, an unregistered firm cannot move the court for any of their claims. It is a disability under section 69. Therefore, the suit has been dismissed. The next paragraph will be of the same applicable law. As per CPC, there is a concept called res judicata. Remember, in professional, when you do something, you already crossed executive. You are not supposed to forget what you studied in executive. So some questions you have to give a reference to that also. As per section 11 of CPC 1908, res judicata means just 2 lines. And then write the principles. Now comes application of the law to this case. In the given case, the firm is subsequently registered and then they move the court. The question is whether this subsequent registration is valid or not. According to section 11, you write the law. The law simply says that, see, if any suit is dismissed on technical grounds, if it is again brought into the court cannot refuse. The principle of res judicata will not apply. The court has to admit. Since this is the law, the second suit will be admitted. You write that thing. Then you say decision. So make 4 paragraphs. Facts of the case, applicable law, application of law to this case, and then decision. What are the advantages? Number 1, among thousands of papers, your paper will be distinguishing because it's been presented in a different manner. Rather than writing in 1 paragraph or making the examiner find it difficult even to find out where your answer is, you make it very clear. 1, 2, 3, 4. And by any chance my law is correct but interpretation is wrong, we will get marks even for that. This is a theory paper. There are many questions which are having 5 marks, 6 marks and all. So out of 6, if I get 3, assuming that somebody writes, yes, he is liable, no, he is not liable, simply without giving proper reasons, may get only 1 for that. Even if my answer is wrong, I will get more than that. We can easily get some fringe marks because we have written the law correctly. So first we have to understand that presentation also matters. Similarly, another 2 minutes I will tell you about distinguish between. For example, you get a question, distinguish between reference and review. So you must first understand that any question that is being asked on distinguish between, first there is supposed to be some common point. Without a common point, there will not be any question on distinguish between. What is the common point in this? Start your answer like this. Question number 3A, 3B, whatever it is, and then write there that difference between review and revision. You write the review and revision, both are covered by CPC 1908. They are the remedies available to the aggrieved person during the suit or after the suit, depending on the case whatever it is. However, they differ in the following manners. You write the differences. Now, when you write the differences, if there are going to be 3 differences, for example, point number 1, reference review or review revision, दोनों का point in which way it differs. Second difference, in which way it differs. Third difference, in which way it differs. Why I am saying this is, some students make a mistake. The mistake is they write all about reference in one paragraph, all about revision in another paragraph, leave it as it is. This is not the proper way. The examination is to test whether you are aware of it or not. If I say I know all about reference, I know all about review, you find out the difference yourself. That is not expected of us. So point wise you make the difference. You can draw a line and write, or you can make point wise, but please make it like that. Distinguish each point wise. Other than that, other questions are short questions. I am not going to discuss much on that because there may be some queries from your side. We need time for that also. Now, to start with, as I told you, old syllabus or new syllabus, there are many things which are common. Right now I am going to cover those topics which are common to both old and new. From exam point of view, even if it is for revision sake, first start with last chapter, chapter number 10. In that, for example, I am now giving a reference to old syllabus, page number 312. Those who are from old syllabus, please take out your book. New syllabus, also keep your book with you. The page number will be somewhere around 333, 334 like that. Compounding of offence and consent orders. The entire preparation or revision of this particular chapter should not take you more than 1 or 2 hours. Very simple. What is it? What do you mean by compounding of offence? When some offence has been committed, now there are various ways. The other party can take me to court. But on the contrary, I say, okay, the mistake has occurred. I will pay some amount. We will settle it officially, legally. That amount, please remember, it is called sum. It is not fine. It is not penalty. It is not compensation. It is called sum. Remember this word. In law, what is very important is use of appropriate words. We can't write haphazard words. So, in compounding of offence, I pay a sum to the government. The sum is determined by the government. I apply. I say this has happened. Hereafter do not happen. If they permit, they ask me to pay a sum. I pay the sum. The matter ends there. But compounding of offence is not permitted in all the laws. Whichever law it is permitted, it is given in the study. And wherever it is permitted, once I pay the sum and compound the offence, the next time I cannot go for compounding for next 3 years. That is, I can't be doing the mistake again and again and then asking, begging their pardon. No. Once I pay, for next 3 years, no. This is compounding of offence. Then we come to consent order. Now, under law you must know, the very word offence means criminal. Only in criminal we use the word offence. For civil we use the word wrong. You might have studied in executive, in law of torts and all. It is wrong in civil. So the first aspect of compounding is relating to some sort of criminal matters. Second is consent order. It is a civil matter, administrative matter. If there is some procedure to be followed, which I don't follow, then I go to the authority and I say, I am sorry this has happened, but it's only a procedure, civil matter, it won't happen again, issue an order. This order is issued with the consent of both the parties. And remember, consent order concept is there only in SEBI, not in others. In this, what kind of question you may get? The question may be either in compounding or in consent order, or it may be distinguished between compounding offence and consent order in general. If the question is distinguished between, one is offence, other one civil or administrative. One is compounding, maybe in various laws, we can see in the syllabus, FEMA and other things also. but consent order only in SEBI. And number 3, if at all you feel this is a difference which you can put it, consent order has not been defined in SEBI. They only made a passing reference that any order passed with the consent of both parties cannot be appealed against. Otherwise, consent order, there is nothing particular. These are the main things. As I told you, you may, with this background, if you study, in 1 hour's time you can finish this chapter. So, compounding of 332 or something, consent order will be around 334 or 335 in both the things. Then, you come to, in old syllabus, study 9, appearance and pleadings. In new syllabus, it is in the last chapter, somewhere around page 320 or 322. In the old syllabus, it is in 302. Now, particularly what is this? When I am going to appear before the authorities, first I should know, as a professional, CS, I cannot appear before the courts unless the court permits. I can only appear in quasi-judicial, tribunal and other things. So when I appear, there is a dress code. What is the dress code? It is given there. As a CS, you appear in a dress code, or if your organization has got a dress, you appear in the dress. Like that, the things are given there. So in this chapter, it is very easy as to what are the various etiquettes. Okay, and then what is court craft, what is the preparatory point and all. In short, the entire chapter I will put it in 2 minutes. When the matter comes up for hearing, you are supposed to go and represent the party. The entire chapter covers only this, in advocacy tips and other things. So what we are supposed to do, we must first know the case correctly. And then we must find out from our party what does he want. Once we know all these things, then you go there and you are supposed to argue it out. Here the word argument does not mean arguing till the end. Here argument only means putting your points, presenting your case logically. Like for example, when you are drafting an appeal, first you write the facts. What facts you write? Right from the beginning. Who am I? Who is the other party? What was the agreement? What was supposed to be done? Where is the breach? We went to lower court. The lower court gave this decision, step by step by step. Like that here also, when I appear, I am going to tell whatever that has been already given in the plaint or written statement. It's a very, very important thing we should understand. If I have not made an allegation in the plaint, even the word plaint is not correct, because plaint is used only in courts. We can say petition. Unless what is given in the petition is argued, other things cannot be taken up. I cannot bring a new point in that, because what has already been given to the court, for that the other party has given a reply, which is known as written statement. So the petition and written statement, they go together. I can argue only on petition. If it is the opposite party, then on the other side. No new point can be done. This is one thing. Number 2, the presiding officer job by time, when he is finding out the truth in a particular way, you try to go along with him and give the truth, rather than confronting him at all levels. And another thing that we follow generally is, if I made a mistake, I say, I am sorry, Your Honor. That's all. I am sorry, nothing wrong in telling that. That is one thing given the conduct, etiquette, important principles, advocacy tips and all. I personally feel in this chapter maybe guideline for professional dress of company secretary and advocacy tips. That is in page 310 in the old syllabus and 329 in the new syllabus. They are important. Try to focus on them, give a glance at the other things. So this covers the last aspect. Now, we come to the major part. The very purpose of this entire study, drafting. I am coming to chapter 1 now. As I told you in the beginning, there is no particular part and all. From any chapter, any kind of question can come. So far, if you see the trend of late, around 30 marks you are getting actual drafting. The questions for approximately 30 marks actual drafting. Not one question, 3-4 questions put together. One more thing I told you, for drafting there is no particular law as to how to draft. But still we follow certain principles. If you take your first chapter, what is important is, they given various things like drafting and conveyancing, drafting and contract, conveyancing and contract, various things. But main thing in this chapter is Fowler's 5 rules of drafting. In page number 5. Both old and new, in page number 5 it is Fowler's 5 rules of drafting. I am sure you must be having your books with you. Otherwise, you take it and then take the page number. I have a bit of water in it. In that also, you have to know one thing. If you see the study in page number 5, follows 5 rules of drafting. They given A to F 6 points. They are not the rules. Please remember, the rules are given in the first paragraph. In that paragraph itself, to be direct, simple, brief, vigorous, lucid. So what does follow said? He said, you make everything drafting, make it direct. Simple, don't complicate. Brief, don't make a story out of it. And vigorous, vigorous means emphatic. Whatever point I want to say, I can't say, I think it is so. Drafting, I think I am the owner of the property. I think the other party wants to buy. No, it must be emphatic. It must be vigorous. And lucid, lucid means clear. So these are the 5 principles, not A to F. Okay, this one point you understand. Then we come to, in the first chapter, some do's and don'ts. Again, in board syllabus, it is page number 7. Do's and don'ts. While you draft, what are you supposed to do, what are you not supposed to do. That's quite simple. The important point is, in the first chapter, that is interpretation of deeds and documents. In new syllabus, it is 11. Old syllabus, in new syllabus, it is 10. In old, it is 11. In the first chapter itself. Now, if you see there are various aids to clarity and accuracy. That is the heading. Within that heading, they have got interpretation of deeds and documents. The possibility is there may be a theory question on this. How to interpret any deed or document. Now you have to go back to executive for preparation. There we have done interpretation of statutes. There are various kinds of interpretation. Golden rule, then reasonable construction, harmonious construction, aegis dum generis. Like that there are various. Strict rule, liberal construction, mischief rule, vagara vagara. So theory question, there is a possibility. If you get a question, try to remember these rules. Please, for your information, once again, just to brush up your memory, golden rule of interpretation, reasonable construction, harmonious construction, aegis dum generis, mischief rule, liberal construction, etc. So they are the principles on which interpretation is done. Another thing you should write if you get a question on interpretation is, there is no law in India as to how to interpret. It is an uncodified law. What is codified? The Parliament or Assembly has passed a law. You go to shop and then buy, I want income tax act, they will give you. But if you say I want law of torts, means which year? It has not been passed at all. Like that, interpretation theory, there is no law passed. So try to remember these rules. Then we come to, in world, they divided first chapter and second chapter, but in new syllabus everything is in first chapter. So then we come to very important aspect of the entire syllabus. What is deed, what is document? Mainly this is where we start our real course. Now basically what happens, anything I write is a document. Simply take a paper and then for example I have written this in my handwriting. This is a document. It is not a deed at all. It is simply a document. Okay? It is simply a document. I have made some notes. But if it is a contract, it requires to be written on a stamp paper. You know, under Indian stamp paper, there are 2 types of stamping, adhesive and impressed. Let us say it's a sale of a house. It must be on impressed stamp paper. Now, if this one is written just like that, it is a document. But if it is brought on a stamp paper, which is legally admissible, that is called deed. So what is the main difference between deed and document? Anything in writing is a document. But if the document fulfills the legal requirements, which can be admitted in court, that is called deed. So this is the first thing you have to understand from exam point of view. Then you just keep the study by your side. I am going one by one. There are various kinds of deeds. Another thing, for distinguish between, the question is quite possible, difference between deed pool and deed poll. Very easy to remember. Even in examination, if you have forgotten what is what, simply what do you mean by pool? By pooling we mean bringing together many things. When two or more people sign, it is deed pool. And only one person says deed poll. As simple as this. Only one person says power of attorney, deed poll. But two people sign any agreement, deed poll. This is another thing. Then we come to indenture and serographer. I am going to show you one thing exactly what is indenture. I am going to show you paper wise. First I am going to show you a very normal document, okay, which is neither indenture nor serographer. It is a normal one. Let us presume we both enter into an agreement running into one page, and this is that page, let us say. This is a normal document, okay. Even if it is on a stamp paper, it will become a normal deed, nothing great. But what I want to do is, I want to safeguard that nobody else does any fraud by taking this document. By any chance, if it is stolen, somebody misuses, to avoid that. What I do, the same document, if there are two parties, they prepare the same document, then they tear it. They do not tear it straight. They tear it haphazard, zigzag, or in any way, so that unless they both originally as it is, they are kept together. I am going to show you, they are kept together, it will not make a paper. For example, this is given to you, and let us say this is given to me. I keep it with myself. Now what happened? Since they are cut in such a way, for example, in the point number 3, for some alleged forgery in the D में E आधा cut होगा, and then in the back B also half cut, which has come in this paper, which is not in this. So assume that even one of us misses the paper. Any miscreant cannot prepare a duplicate and then make it like that, because exactly in which letter, which is cut in what manner, how it is cut is very difficult to forge. This was what thought of once upon a time. This is called indenture. Now we come to further modification of indenture. Then what some people thought was, when we are cutting it zigzag and showing, we will make it still safer. How? We will write something called serographing in between. We will write serographing like this, and then again zigzag to cut it. Now not only the document is cut, instead, in addition, these letters are also cut. So whenever anybody is preparing any duplicate, he has to make another one, another half part of it, because my part is safe, other person's part is not safe. He has to make another half and also type it in such a way that here half means there also it should be half, and then serography also should be cut in such a way. It will be very difficult to forge. This was what thought of once. So if you get a question of difference between deed and document, we discussed. Deed pool, we discussed. Now indenture serography. This means that to make the document safe, when the document is made, depending on the parties, it is divided in such a way that it is not exactly cut, zigzag way, it is cut, given to different parties. Then even if they misplace it, anybody else preparing it, it will be very difficult to prepare a duplicate of that kind. Then to make it further safe, they added serography. Okay. Now, so if you get a question on indenture and serography, you have to add one more thing. These things do not exist now. Remember this, they are no more existing now. Once upon a time, it was there. Then comes complements of deed. Here comes our major part. As I told you, you may get questions for around 30 marks for actual drafting. When you go for actual drafting, there is a method how to draft, even though there is no law. What is it? You take the page. One by one, we will spend a little bit time on this because this is the most important thing. In your study, it is page number 20. Okay? In your new study, it must be 15 or 16. Whenever you get any question, draft an agreement or whatever it is. Let us take an example, draft a So first it must have a heading, the title to the deed. Okay, you can write it either deed of lease or lease deed. Remember, write it in capital letters and underline. So your first point is write the heading first, because in law there is a principle, form and contents. If I say lease deed, inside I make it a gift deed, only gift deed is valid because contents matter. But as a professional, when we make it, the form and content should match because we are professionals. So first make it as the heading first. That's the first step. I am telling you, it is very easy actually how to draft. Just follow these steps. First step is make the heading, lease deed or deed of lease. Then comes next. Now you must remember the concept. In drafting, in agreements, it will never be you, I, he and all. For example, if I am going to sell a house to you, it will not be that I am selling a house to you. It will be Narayan selling a house to somebody, X. But all these agreements will be written in third party. That means, from the reader's point of view, it is two different people doing. Reader does not do it, he only reads the document. So, what are the informations you want? That's what we are supposed to do. Simple concept. Your agreement should reflect the matter in such a way that somebody else is reading. When he reads, what is he finding? He is finding first the title, deed of lease. Then what does he find? This deed of lease, remember, this also should be in capital letters. This deed of lease, capital letters. Then you come to small letters. Executed at. In this at, you will not give the exact address. You will write the place. Remember, executed at me, you will write the place. For example, executed Delhi, Kanpur, Chennai, that's all. No individual address, separate address. Again, going back, first the title. Second, this deed of lease, this deed of sale, this deed of mortgage, whatever it is, in capital letters, both. Title as well as up to this capital letters. Then, small letters में executed at. Capital letter में place करना. Then on the date. Date preferably you can put it in totally 13th December 2015, fully in writing, nothing wrong with it. That is always better. So again and again I will be repeating from the beginning because it will be easy for you to remember. Title, this deed of lease in capital letters, title also in capital letters. Then executed at, small letters, place, the name of the place, capital letters, on, again the date, whatever it is. Up to now, okay. Till now, what the reader has read, I assume that he is the reader. He has read so far. Okay, this is lease deed. This has been executed at this place. Executed on this date. Between whom? That is the next concept. Because he should know who are the parties. So between. Now we start the party's name. Between X. Now let us say X name is Arvind Kumar. There may be thousands of Arvind Kumar in this world. So Arvind Kumar, son of. Or if it is lady, daughter of, or husband of, wife of, whatever it is. So that is very important for further identification. The name, for example, son of Kumar. Then you come to resident of. That resident of is, now you give the full address. Full address of that party. Okay, now who is he? He is the lesser. Is it not? So, resident of, hereinafter referred as lesser. That means now the third party will know, okay, this party is the lesser. Why? Because the entire agreement will not give the name of Arvind Kumar hereafter. The entire agreement will only give the reference of lesser, lessee, vendor, vendee, mortgagor, mortgagee, like that. So, title, this deed of lease, then small letter may executed at, name of the place, capital letter, executed on, between, name of the party, capital letter, son of or daughter of, whatever it is, again capital letter my name, resident of, then you come to hereinafter referred as lesser. Then what happened? There is a complication. Arvind Kumar is giving it on lease. If something happens to Arvind Kumar, then his successors or legalers, if they refuse, there can be a problem. This problem will be aggravated if it is instead of lease, it's a sale. Tomorrow if there is objection, therefore something will be added. I will give you with the page number. Try to memorize it. That is very important. In word syllabus, page number 23. Okay. it is given in point number 3, description of parties. Just before the point of recital. In new it must be somewhere around 17 or 18, something like that. Okay, I'll tell you that also. It is in page 18. New may, it is in page 18, very important. You must write there, hereinafter call the lesser ke baad. Okay. Now, we can say last may, you just read it. Which term shall mean, and unless it be repugnant to the context. Now, assume that you forget certain technical, this particular words, no problem. Which term shall mean, unless it is repugnant, is legal as, success, etc. Okay, because otherwise what will happen? The point is the legal heirs may object to it. Now, in case it's a company, we will not use the word legal heir, we will only use the word legal representative assign. Assign here means assignee, because not an individual. So, when we say hereinafter referred as what, then we also write hereinafter. It will, which term shall mean all those things. And then you write of the one part. What do you mean by of the one part? Please remember, it is not one party. It is one part. The agreement has got different parts. One part is lesser's part, other part is lessee's part. That is the meaning of the one part. Of the one part, you put it in capital letters. So far what happened? The title, this deed of something, up to now capital, at, on, between, the party, father's name or wife's name, husband's name, whatever it is, and then address, which term, what is he called as, which term shall mean all those things. Of the one part. Up to now, this of the one part will be in capital letters. Now this is one party, there is going to be another party. So you are going to bring in the other party. Now what you do is, for getting better marks, next line, in the next line you write and in capital letters. Don't add it with that. Make everything into one paragraph, no. One part, then and, come to the second part. Again you write Krishna Kumar, let us say, the other party. He is the other party. So again, son of or daughter of, resident of, then hereinafter referred as lessee, which term shall mean all those things of the other part. Up to this thing, if you do it properly, what does it imply? The third party now knows who are the parties to contract, what is the title of the contract, when is it executed, where is it executed, and what are they going to be referred in future. Up to now we covered so far in point number 1, 2 and 3. In between there is some question. Once or twice you have been asked this question. What is the importance of place of execution? What is the importance of date of execution? Very important. Try to understand this. We bring the CPC and Registration Act into account. Depending on the place, the registration will take place. Depending on the date, a limitation period will work. Because you know different documents have different limitation periods. Limitation period will work. So for that purpose they are important. Similarly, you come to description of parties. Parties, it is very important to make a mention, as I told you, all those things. Now, this is one part of the agreement. The second part comes to recitals. Now, assume that you are the third party. Now you are wondering yourself, okay, this person is the lessor, this person is the lessee, but how did he get hold of the property? Is he the owner? This problem may come particularly in sale. Am I the owner to sell my property? If the property is not mine, I cannot sell. So how did I get the property? Now comes the next aspect, recitals. Recital has got two parts. One is called introductory recital. Okay? Other one is called narrative recital, we call it. Now what does it mean? The one part says, whereas. Remember, recitals will always start as whereas in capital letters. And you will not write recitals. Recital is only the concept. In agreement, you will not write recitals. You will only write after the, after writing both the parties, you write whereas. That is, you are starting a story. Whereas, so and so became the owner of the property as per. No need to take it back to 200, 300 years. How did he get hold of it? Probably, let us presume, his grandfather bought it. Then, after he died, it came to the father. Then he divided. One portion came to me. Like that it can be. So how did I get hold of the property as a seller, as a lessor, as a mortgager. So that is whereas. So one part will be covering whereas he is the owner of the property as per whatever it is. But that is not sufficient. You know, even as per English grammar, if you start with whereas, the sentence has to complete. So the next paragraph, and whereas the other party is interested in taking it on lease, or other party is interested in buying this house. Now, so I am the owner, one whereas. Next whereas is I want to give it on lease, or I want to sell it, and whereas. Then again, and whereas, you can write even 100 and whereas, nothing wrong with it. Make it into beautiful points. Whereas so-and-so is the owner of the property, and whereas he wants to sell it, and whereas the other party is in need of property, and whereas he wants to buy it, and both of them agree for this up to now. Now the reader will know that why he wants to sell, or why he wants to lease, why the other party wants to get. This is the second part of the agreement. First part is the beginning, second is the reasons. Agreed. Even then, so what? He wants to give, you want it, so what? Where is it? Now this agreement witness. Now I come to this, which is called testatum. This testatum, again you will not write testatum. This concept is called testatum. Now that will say, now this deed witnesses. There are two ways of doing this. One is now this deed witnesses. Other one, now this deed witnesseth. You can write anything you want, nothing wrong. That appears to be more legal, that's all. Otherwise nothing wrong with this. So, to the reader you are now telling, now this deed witnesses what? Now you are going to read the points. If you take your study, there are so many agreements given. All these agreements may be having around 20-25 points. They are all inclusive, but it will be difficult for us to remember all these points. So go for the basics, because your question will be for 6 marks maybe. For 6 marks you can't write all those things. What is the basic? Lessor, lessee. There are two parties in the lease agreement. Imagine yourself, if you are a lessee, you are going to be on rent, what do you expect the lessor to do? This is the first part. If you are a lessee, what do you want the lessor to do? So you make it the point number 1. Now the lessor agrees. 1, 2, 3, 4, 5, 6 are points. Then you imagine yourself to be the lessor. What do you want the lessee to do? Point number 2. Now the lessee agrees. Simple. Remember, just give a glance in the study. In examination, just close your eyes and imagine yourself to be this party or that party. If it is going to be a sale, you are the seller of a house. What do you want the buyer to do? Then after some time, think yourself to the buyer. What do you want the seller to do? But always in this operative class, first we write about the seller's things. Then we come to the buyers, whether rights or duties, whatever it is. So, after the recitals, we came to testatum. Testatum is only one line. Now this is witnesses. But in most of the contracts, except gift, consideration is involved. That is the main purpose. Without consideration, there is no contract. And the consideration, if it is not acceptable, again there is no contract. Therefore, in the operative part, first we write about consideration. That is, if you see in your study, after testatum, you go for consideration. Now this deed witnesseth as follows. Then write point number 1, the consideration. What is the consideration? Whatever it is. Now the lessee hereby agrees to pay lessor a monthly sum of 10,000 rupees for 3 years, whatever it is. Consent from. Okay, you put it. Consideration. If it is a sale or purchase, some advance payment is made. So you write that this much money has been paid by advance, paid in advance by way of check number, whatever it is. And not only that, one party says I have paid, has the other party accepted? So you have to add there, and the other party also accepts the receipt of the sale. That is point number 6 and 7. So in your operative part, the first thing is consideration of giving and taking. Simply giving is not sufficient, because other party may say I have not taken. Giving and taking, this is first part. Then you come to various things. Depending on the type of contract, various things. I suggest, if you do not have time, or you do not remember all, at least go for the basic things. What are things you want to ensure? If you give your house on lease, what do you want the lessee to do? Sorry. You want the lessee to maintain it properly, to pay rent regularly, vacate in case of breach or if it is not renewed. These are the basic points. If you are a lessee, what do you want the lessor to do? You want him to give the house in good condition, and any kind of permanent repairs the house owner has to do. Like that, there are certain things. And if at all it is going to be a big commercial lease, you can go for arbitration clause also. But normally for individual lease of one person taking a house on rent for staying with family, we don't go for arbitration clause. That is unnecessary. Otherwise we can put like this, some 5-6 points you make it. Then you come to, after 2 pages you can find point number 14, testimonium clause. That is the last part. You got questions once or twice, difference between testatum and testimonium. Remember, testatum only means witnesses ki what happens. This deed witnesseth what? That is testatum. What is testimonium? That is the final part. That final part says, in witness whereof the parties here to have signed. If you forget the legal words, make it simple. In witness whereof the parties here to have signed this document. And always on the right side there will be party signature, on the left side there will be witness's signature. The party signature, the first person to sign will be the lessor, seller, like that, because he is the first party. And witness may, there can witness, I will tell separately afterwards about witness. So this is about this, here 2 witnesses. Now this completes our agreements. Any kind of agreement you get in examination, please remember, any kind of agreement you get in examination, all you have to do is to start with, this is the last time I am telling you, due to paucity of time, so it will be easy. The title, this deed of something in capital letters, executed at, or again don't write executed, small letters may executed at Kanpur on date between one party is in first party ka name, son of or daughter of, resident of, then hereinafter referred as, then this term shall mean all those things, whatever it is, of the one part in capital letters. Next line mein, and again other party ka complete details of the other part, full stop. Then now this deed witnesseth as follows. Other than gift, even power of attorney, because there may not be any consideration in that. In such cases you write the consideration part, given and taken. Then now the lessor agrees, lessee agrees, whatever it is. Then you write in witness whereof whatever it is. That is the testimony. If you do this out of 6 marks, even by chance I have not written all relevant points in operative clause, only 1 or 2 relevant points, but the other things I have written properly, the format also will be valid. Remember, in actual drafting, other than appeals and all, in actual drafting there is no law, so go for the basics, follow this method. Out of 6 marks you will easily get 3 to 4 marks. If I write the operative part also properly, giving all relevant points, need not be all 25 points, at least 5-6 relevant points, you can even get 5 out of 6 depending on your handwriting. What else we want? Okay, this is one. Then in between, there is something called in parcels clause, point number 10. If you get a question on that, you have to first write these things do not exist now. Because when I am selling my property, what am I actually giving? I need not have, I am giving the staircase also. No. But if it is a lift, I have to write there, it is along with lift. If it is a garden, I have to write along with garden. Certain things I am giving along with it, all put together they are called parcels. But now section 8 of Transfer of Property Act says, unless it is told otherwise, when a property is sold, all inclusive are transferred. So that point you write, that is important. Then you can very basic things, attestation. Regarding attestation, I want to tell you something. You may get a general question also on attestation. First thing you understand, attestation does not attest the contents. Please remember this. If I am selling my Taj Mahal for 100 rupees, assume that it is mine, I am selling it for 100 rupees, somebody witnesses, the witness cannot say, how can you sell it for 100 rupees only, or how can you sell it for 1000 crores? It is none of his business. Attestation only means the person attesting confirms the signatures of the parties. He he is not confirming the contents of the document. Very important. And number two, the signatures, even though are expected to be put in his presence, it is also possible that I may sign now as a party, you may attest it afterwards. Once I give a letter to you, this document has been signed only by me. Taking my confirmation along with the document, you can sign it afterwards. Nothing wrong. If the document needs two witnesses, it is not necessary that each witness should attest both the signatures. No need. One person, there should be two witnesses, and they both should put together confirm the signatures of the parties. Okay, remember this regarding attestation, very important. And one more point, it is not necessary for all the documents, but only for a few. But nowadays what happens, as a matter of abundant precaution, we attest every document. Okay? Then this chapter, nothing particular. This is in new syllabus chapter 1 and old syllabus chapter 1 and 2. Very important. For your 25 to 30 marks you can get out of this. Not out of this, by following the pattern. Then we come to drafting of agreements. Okay. Sorry friends, we had a short break because I just needed a break, but I didn't inform you in advance. I'm very sorry. We will proceed now. I think before the break we were going very fast because the time is very short. We have to cover a lot of topics. Now I'll try to manage it both ways. We come to the next chapter. In the old syllabus it is chapter 3, the new syllabus it is chapter 2. Drafting of agreements. In this there are various kinds of agreements. You straight away take the first one, important points in regard to drafting of contracts. Old syllabus page 34, new May 28. There are various points given. In this, I want to tell you one thing about point number 11. It is about passing of the property and passing of the risk. You know, it's a very important concept. There can be practical question also as to when does the risk pass? Because I am sending you some goods. On the way the goods are damaged. Who can claim compensation? That's very important, because in all international contracts, when goods are going from one country to another country, even in domestic contracts when they are going from one place to another, there is always a problem of who will get the compensation, who can claim. So there is a maxim called risk follows ownership. Please remember this. Risk follows ownership. You have to first determine as to who is the owner at the time the loss occurs. Whoever is the owner, he will claim compensation. This is one. All the other things are quite simple, you can go through. Then, now we start other thing. There are various agreements, for example, sale of house property, agency and all. In each type of contract, there is some special feature. Remember, in many contracts, there are some special features which we must remember. For example, sale of house property or building contracts. In both, what is the common feature? That is, time is of essence. It's very important. When that contract will be complete, when the building will be complete, the time must be mentioned, and if it is not completed within such time, what is the compensation paid? This is another thing. Then in case of building contracts, for example, if you take this page 46 and 35, 46 in old and 35 in new, building contract. Now what is this? I have a land, I want some builder to build a house and give it to me. This contract should cover all. So building contract on top, this building contract or deed of building contract number, the deed of building, okay, entered into on vagera vagera, as I told you already. But what are the important features? The important features are, when a building is constructed, the architect must be allowed to go and inspect during construction. Because once construction is over, then architect, however much he tries, it can't be changed, it will be a waste of money. So during construction, the building contractor has to allow the architect. This is one important point. Second, as usual, time is of essence. Within what time it must be completed. Number 3, during construction, the materials are put at the place where it is taking place. Who is responsible for loss of materials? This also must be mentioned. There will be a security guard at the cost of the contractor. He will be able to bear any loss and all those things. So these are some important things with regard to these two types of contracts. Then we come to, from exam point of view, del credere agency. You got questions on this many times. Now, commercial agency contract. It comes under the topic. If you get a theory question, first you must always write what, in which law it is covered. For example, agency is covered in Indian Contract Act. I will give you one more hint. If you find any agreement for which there is no particular law, please remember this, very easy in examination. If there is a particular agreement for which there is no particular law, it is covered under Contract Act, because contract covers agreements. It's a common point. So agency is covered in Contract Act. There, a particular type of agency is del credere agency, where the agent also undertakes to collect the money and then give it to the principal from the third parties. On this you get questions many times. Then the next important thing is foreign collaboration agreements. Page 56 in bold and around 45 or so in the new syllabus. In this I want to tell you certain things. Foreign collaboration agreement in India, there are two routes, automatic route and government route, which is called approval route. In automatic route, they are given certain principles, certain rules. If I follow those rules, authorized dealers can permit, the matter is over. But if there is going to be deviation, then the permission of the government has to be taken. What are those rules? Number one, whenever any collaboration is made, I may be paying royalty. The royalty, lump sum royalty, can be paid up to $2 million under automatic route. The lump sum royalty, maximum $2 million, though it comes under automatic route. But even though it is called lump sum, it is paid in 3 installments. When the agreement is made, subsequently when it is delivered, subsequently when the commercial production starts. Three parts, 1/3, 1/3, 1/3. So at the time of agreement, maximum 1/3. Then when the technology is given, another 1/3. When commercial production starts, the remaining 1/3. So even though it is called lump sum, it is not paid in one sum, it is paid in 3 installments. This is first point of automatic. Second point is periodical royalty. By using the technology, I am manufacturing some product and I am going to sell it locally or export. Then what can be the royalty payable to you? Because it is your technology I am using. So the royalty can be 5%, 8%, everything is given in the study. 5%, 8% of my sales. In case of domestic 5, export 8. So this is second point. Now, assuming that I want to pay more royalty or I want to pay more lump sum royalty, then it is government route. Where as long as it is within limit, it is automatic. Number 3 point, it is, I saw it in the whole study, it is no more there. I wanted to make the change. Page 56. In world syllabus study, page number 56, there is something on duration of agreement. Okay, it is not in the new one. Page will be around 45. Now, duration of agreement. In new also it is found there. Now they are given there. The period is approved by the government usually for 5 years. That is when we go for the approval route. Otherwise, normally what happens, as long as the duration with regard to royalty is concerned, the government does not say anything. That if I am going to use your technology and manufacture something and sell it, I can pay royalty as per mutual agreement for whatever be the period. But when the agreement is going to be approved by the government, then the government gives this much of period. This is one thing you have to understand. Otherwise, there are only 2 main aspects. That lump sum royalty payable in 3 installments, maximum $2 million. Periodical royalty on local sales and on exports, the limit. If there is going to be any deviation, it is approval. Then we come to next is arbitration. The next point you can see that. Now what is this arbitration? If you get any theory question on arbitration, because there are remaining 70 marks you will get only in theory. If you get it on arbitration, first I will give you some important tips in that. Arbitration is not compulsory, number 1. it is optional, at the option of the parties. And the arbitrators are not called arbitrators, they are called arbitral tribunal, even if it is a sole arbitrator. If there are more than one arbitrator, they are called arbitral tribunal. Assuming that we appoint 2 arbitrators, then each of them will appoint a presiding arbitrator. All of them put together known as arbitral tribunal. Then, when it comes to arbitration, under normal law, people have some dispute or people may expect some dispute. Therefore, arbitrator can be appointed either before the dispute or after the dispute. Remember this. Arbitrator can be appointed even before the dispute. Like for example, in vehicles and all, in case of insurance claim, if there is a dispute, so and so will be the arbitrator. So it can be before dispute or afterwards. Arbitrator, if both parties join, please remember this, if both parties to dispute or agreement, they join and appoint, the arbitrator has to be only odd number. But if each party can appoint arbitrator, then the result will be, naturally it will be even number. Assume that I appoint 2, you appoint 2, it will be 4. I appoint 3, you appoint 3, it will be 6. So the result will have to be even number. In such case, those arbitrators will appoint another person called presiding arbitrator. All of them put together known as arbitral tribunal. Next point, with regard to mainly from drafting point of view. In arbitration, the decision given is called award. The award must be in writing. It must be on a stamp paper. Then it must be signed. With regard to signature, you got a question also recently in one of the examinations. The arbitral award is expected to be signed by all. All means all, members of the tribunal. In case it is not signed by all, even a majority can sign, sufficient. But they must give the reason for omitted signatures. Remember this carefully. Your question was, the award was not signed by all. Is it valid or what? The award expected to be signed by all, if not at least by majority, with reasons given for omitted signatures. This is with regard to arbitration. Then we come to guarantee. Here I want to refer to the book also. Take page number 64 in old, maybe around 52 or 53 in new. It is very necessary to understand these small points. If you see there 52 in the new thing and the 64 in the old, there are various kinds of guarantees. Normally a guarantee, what is a guarantee? Guarantee is that you will perform something. If you don't perform, then I will do it. For example, A borrows money from B. C says A will repay, otherwise I am there to repay. That is guarantee, simple concept. So what is a particular law? It is Indian Contract Act. 1872 is the law for guarantee. Then guarantee, there are various types. One type is called fidelity guarantee, where an employee, for example a cashier is there. A cashier will not run away with the money. He will not embezzle the money. Then somebody has to give guarantee for that cashier, even at the time of appointment. That is called fidelity guarantee. This person will not misconduct himself. A guarantee given by somebody is called fidelity guarantee. Okay. Then there is something here called counter guarantee. It's a very peculiar thing. What is this counter guarantee? Normally what happens? If A borrows money from B, A has to repay. A is called principal debtor, B is called creditor. C gives the guarantee. C is the surety. This is the normal 3 parties. Now, C gives, in return what C gets? So C enters into an agreement with A, the principal debtor. Whenever I pay money on your behalf, then now you give me guarantee or get some guarantee, give me some assurance that you will pay me back afterwards. So initially the surety stands guarantee, in return he gets other guarantee. You just read there, a guarantee given by the principal debtor to the surety, providing him continuing indemnity against any loss the surety may suffer on account of default of the principal debtor. So if principal debtor A makes a default, then C comes into the picture, he makes payment. In such case, A gives the guarantee, don't worry, I will compensate you. That is counter guarantee. What is performance guarantee? A agrees that I will construct this building within such and such date. This bridge will be constructed. If not, I will repay this money. I will pay you this money, somebody gives guarantee. That is performance guarantee. Bank guarantee is for import-export financial transactions. In guarantee, the most important thing from examination point of view is liability of surety, page given 53 in new and old means 66. Now, when does surety's liability occur? If today A has to pay money to B, A does not pay. Now, what are B's rights? B has to, one option is B has to go to court against A. If A does not pay, then recover from C. This is one option. Other option, straight away come to C. Since he has not paid, you pay me. Which is correct option? The second one. That is what is called the liability of the surety is coextensive to that of the principal debtor. What is coextensive? Coextensive means arising at the same time in the same manner. That means whenever the principal debtor is liable, simultaneously surety is also liable. So there is a question asked in the past whether the creditor can recover directly from surety instead of claiming from principal debtor. Yes, it is possible. Principal debtor से पूछ के उसके बाद ही आने का जरूरत नहीं है. Straight away they can go to surety also because liability of the surety is coextensive of the principal debtor. This is very important. Then other things very simple in this. As I told you, our time is short, so we are going for important things. There are some questions also. I will be covering them also. Then in the old syllabus there is next chapter, drafting of various deeds. Okay. Here it will be on. Yeah. This is new also. It is lesson 4. In that, if you see, initially it will be immovable property. We will not bother. We come straight away to mortgage. If you get a question on mortgage, which is the law applicable? Transfer of Property Act 1882 is the law applicable for mortgages. What is a mortgage? Somebody borrows money from another person and then he says, don't worry, I will give you my immovable property as security. If I don't pay, this can be used. So what are the important features? Number one is only with regard to immovable property, mortgage term is used. Now I want to tell a little bit about various kinds of such contracts where some security is given. Because one question also I got already on that, so I am just telling you. There is something called pledge, something called hypothecation, something called mortgage, something called assignment. There are various things. Now, pledge is something only movable property. If I am going to give this as security and borrow money, it is pledge. If I am going to give this building and borrow as security and borrow money, it is mortgage. So first is pledge, movable property, mortgage, immovable property. What is hypothecation? That is also movable property. But in pledge, what happens? The item that is given as security is given to you and then you give me money. In hypothecation, I borrow money, I also keep the security with me. So, the secured asset jo hai, that also remains with the borrower, that is called hypothecation. Then, don't you think there is a risk for the creditor that in case I don't pay, I may even sell it. Therefore, what happens is, that in hypothecation, see, I will first tell you what is the purpose of hypothecation. Hypothecation, the very purpose is, if I give the asset to you for borrowing money as security, then I can't repay because I have to use the asset to repay. I will give an example. I go to a bank. I want to buy 10 cars for tourist purposes. Tourist cars. I buy 10 cars, borrow money from the bank, I buy 10 cars, give the cars to bank. Then how will I run the car? How will I earn money? How will I repay? So here comes hypothecation. I keep the car also, I put there hypothecated. If I don't repay, the moment I default, you got a right to take back the money. In pledge, I don't need air conditions during winters. I am a AC manufacturer. So what I do, my stock of air conditions, I give it to the bank, pledge, borrow money, make further air conditions for next year. How do I give? I don't give physically. In pledge, there is something called KCC, key cash credit. I give the key of the godown. The moment I give the key of the godown, the pledge is created. So first is pledge, then hypothecation, then assignment. Assignment is nothing but I have a right over certain assets. Those assets ke upar whatever right I have, that right I am transferring. For example, sundry debtors. As a company, I supplied goods on credit, so there are certain people who have to pay me money. Now I want to borrow from the bank. I want to give sundry debtors as security. I can't give them physically take them and lock them into the bank. Instead, what I will do, I will total it and then say, tell the bank, these are the people who owe money to me. You give me money. If you don't repay from them, you can recover. That is assignment. Mortgage is only for immovable property. Now, coming to our mortgages, there are 6 types of mortgage. From exam point of view, there are 6 types. Simple mortgage. I am not going to explain all the types because you might have done it in executive. I am only going to tell you one special feature of these mortgages. One is simple mortgage. Other one is mortgage by conditional sale. Other one is usufructuary mortgage. Next one is English mortgage. Next one is mortgage by deposit of title deeds or equitable mortgage. And the last is anonymous mortgage. There are 6 types of mortgages. Now, in mortgage when you study, what are the important things you have to remember? One, whether the property is going to be given to the other party or not. That is, or I am only going to occupy those continuously. For example, it's a simple mortgage. I need money, I go to the other party, I say, I am creating simple mortgage, I will continue to stay there. No problem. May or may not be transferred. But in usufructuary mortgage, you will be able to recover the money of the mortgage only by utilizing the property. For example, I got a big shopping complex. Now, I have given to various people on rent. I am going to borrow money from you. I am giving this usufructuary mortgage. I tell you, I will not pay you the money. You recover from the shopping complex, adjust your loan. After it is repaid, you give back to me. It is not called giving back, it is called reconveyed. Remember this. For movable property, giving back is called return. For immovable property, giving back is called reconveyed. This is a technical term, appropriate term for that. So that is the second one. So out of these 6 mortgages, one mortgage, that is mortgage by deposit of title deeds or equitable mortgage, is not registered. All the remaining 5 mortgages have to be registered. This you remember. Because in all the 5, only the mortgage deed is made. The title deed remains with me as a mortgager. But in the case of equitable mortgage, I give the title deeds also. So there is no possibility of myself selling it again to somebody else. Therefore, that need not be registered. It is only equitable. All other mortgages have to be registered. Then, there is next one is about lease. Now coming to lease. In fact, in mortgage there is one more point that has been covered there. There is something called sub-mortgage. I mortgage my property to you. I am the mortgager. You are the mortgagee. You mortgage it with somebody else for your borrowing. You mortgage my property. Therefore, sub-mortgage requires the permission of the original mortgager. Second mortgage. I mortgage my property to you and borrow money. I need some more money. I mortgage the same property with somebody else and borrow money again. That is second mortgage. It does not require the permission of the original mortgagee because after all it's my property. In case I don't repay both of you, the first mortgagee will get all the rights exhausted, then only the second mortgage will come. This is the aspect with regard to sub-mortgage and second mortgage. Then, here if you go down the same chapter, you come to lease. Which law applies for lease? Transfer of property, section 105. That applies for lease. Again, lease is only for immovable property. Okay? In lease, what are the important points? First, whether the lease has to be registered or not. Remember this, if the lease is for more than 1 year, exceeding 1 year, it has to be registered. If it is 1 year or less, need not be registered. This is with regard to lease. I am the lessor, you are the lessee, the property is the leased property, that is immovable property. So registration over. Then afterwards in lease also there is something called sublease. You can sublease the property with my permission. Then other things we are not bothered about lease because they are only in executive or delete. Then we come to lease and license. Afterwards we will see the next chapter also. Then in the whole syllabus, study 4 over, we come to study 5. In new syllabus also it is study 5. Okay, you take the study 5. First, as I told you, it is about assignment. What is assignment? As I told you, it is my right to recover something. That right I am transferring to you. That right transfer is called assignment. So assignment deed. I am the assigner, you are the assignee. Then we come to intellectual property rights, IPRs. In IPR, please remember when you are drafting the agreement for IPR, some basic concepts I will give you. In study, they are given only 3 IPRs, patent, trademark and copyright. But in general, there are 6 IPRs broadly. Only I am just giving the outer reference. Try to remember this thing. Each IPR meaning you will be knowing. But what is important is what is the lifetime and whether it is to be compulsorily registered or not. 3 IPRs are to be compulsorily registered and 3 IPRs need not be compulsorily registered. What are the things which are to be compulsorily registered? Patent, designs and layout design. There are 3 things. Integrated circuit layout design. There is another thing. That is your transistor TV में जो भी IC है, it is relating to that. So there are 3 IPRs which have to be compulsorily registered. Patent, designs, industrial design. 3 optional. Copyright, trademark and geographical indication. They are optional. This is the first point you have to remember. Second point, when you are drafting. Second point is that what is the lifetime? Patent is valid for 20 years from the date of patent. After 20 years, anybody can use that invention. It is called, it has become public domain. Public domain means public knowledge. So patent lifetime is 20 years. Design, 10 years first, which can be extended once for another 5 years. So totally it will be 15 years. Design is total 15 years. Then you come to layout design or integrated circuit IC wala. That is similar to patent, 20 years, because there is something technical in inherent nature. So 20 years, 10 plus 5 and 20 years. Come to optional, copyright. Copyright is valid for 60 years from the beginning of the calendar year following the year of death. Assuming if somebody writes a novel, he dies today, then his legal heirs will have copyright on that particular novel. How long? From 2016 January 1st, 60 years. And from today to 31st December also. That means from the date of death to 31st December plus 60 years. This is copyright. Then we come to trademark. Trademark is permanent, but once in 10 years it has to be renewed. Geographical indication similar to trademark. These are the main things with regard to these things, with regard to IPR. So you get any question on IPR, theory question, first write what do you mean by IPR? General. After all, you can't simply start straight away with patent. You have to write what do you mean by IPR? Intellectually, when somebody has created something, he must have a right over it, commercial over it. Particularly IPRs are called negative rights. What do you mean by negative right? The other party cannot use it without my permission. That is negative right. Then you write there are various things, compulsory option. One more thing I will tell you about IPR. You find 2 words used in IPR. One is infringement, one is passing off. These are the 2 terms used in IPR. Whenever any IPR is registered and that is used by other party without permission, that is called infringement. Whenever any IPR is not registered, if the other party tries to use it as if it is his own right, that is called passing off. So registered IPR when it is violated, infringement. Unregistered IPR when it is violated, passing off. Simple concept. Then we come to partnership. Partnership I am not going to discuss much because you must have done a lot on partnership already. Very simple. Trust. Trust is a peculiar thing. With regard to trust, I will tell you, the act is called Indian Trust Act 1882. The person who creates the trust is called author. The other party is called trustee. And the person who has to get the benefit is called beneficiary. In this, what are the important theory concepts? I will tell you one by one. This act applies only to private trust and not to public trust. This is the first point. What do you mean by private trust? When the beneficiary is certain, ascertainable, that is private trust. A creates a trust and says the trust money should go to B. Appoints B as trustee and says trust money should go to C. The beneficiary is C, identifiable, private trust. There is a public hospital, charitable trust runs a hospital. Anybody can come and get the treatment, public trust. This act covers only private trust. This is number 1. Number 2, author can be a trustee sometimes. When he creates a public trust, he can be a trustee as long as he's alive, he can manage the property also. Author can be a trustee, possible. Author can be a beneficiary. When he has to get the money, he goes abroad, he asks somebody else to create his account. So, author is the beneficiary, possibility is there. But trustee cannot be the beneficiary. Remember this carefully. A trustee cannot be the beneficiary. This is the next aspect in trust. Another aspect is with regard to trust. It can be movable property or immovable property. If it is immovable property on which trust is created, then it must be in writing and registered. If it is movable property, it can even be oral. Then last important point with regard to trust is that a trust can be revoked. By whom? By beneficiary competent to contract at any time. By trustee with the permission of the court. By court any time. But the author cannot revoke it unless he has put it in writing in the trust deed that he has power to revoke. Very, very important concept. The author, the owner of the property, before creating trust, he cannot revoke it unless he has expressed his right to revoke in the contract. This is another aspect. Then comes power of attorney. This power of attorney in the new syllabus, it is covered in some other chapter. Those who are from new syllabus, you can take page 80. In the old syllabus, we are doing continuously page 2029. Now in power of attorney, I will give the important concepts. Generally, all agreements are made by two parties, this person and this person. But power of attorney is always by one party. I, so and so, son of or daughter of, I represent myself, I refer myself totally. And then I say I give power to somebody to do certain things. Power of attorney can be revocable or irrevocable. And power of attorney can be general power of attorney or special power of attorney. For example, I give power to A to operate my bank accounts. That means he can do anything in my bank account. He can even borrow money against my deposits, vagera, vagera. Then that is general power of attorney. But I authorize B to only borrow money from bank by pledging my, deposit certificates. Then that is called special power of attorney. So whenever I give power to somebody to do only a particular thing, that is called special. To do generally anything, that is called general. I am called the principal, sorry friends, and the other party is called the donee or agent, whatever you call it. That is with regard to power of attorney. Then, up to now we have seen in every chapter whether it is to be registered or not, what is the stamp duty payable, whether they should be attested or not. So what I suggest is, you got 10 days time, it will take only 1 hour. Because topic wise you take, for example, power of attorney, make second column. First column, what are the claims? For example, power of attorney, trust deed, whatever. Second column, is it to be registered or what? Third column, should there be stamp duty? Naturally, if it is to be registered, there should be stamp duty. Then, should it be attested? Make column and then write it down. When you write it, you will remember it better. And before exam, you can just give a glance in your house and then leave it there. Okay, that will be very easy for you. Because these are the common things. Then, study 6, drafting of agreements under Companies Act. This is under the old one. The new one also, I think, is study 6, study 7. In this, again, if you see there, in your study, some reference has been given to Companies Act 1956. But you must be knowing that the Act has changed. There are various things. For example, object class, there are changes. Main object, other object, incidental, they are all not there. So, that part you make a change in this based on our Companies Act. But I got one question from somebody about shareholders agreement. Okay? This is not in the old syllabus if I am not wrong. But whether it is there or not, just go through it. In the new study, it is there in page 260. Those who are from new syllabus, take page 260. Now, what is the shareholders agreement? Now, some people agree that we will manage this company, we will own this company, we will manage the company to be, which is already there, or to be formed, whatever it is. If you take shareholders agreement in page 260, this line completely explains everything. Shareholders agreement, within that heading, 4th line, Shareholders agreement is a contractual arrangement between the shareholders of a company describing how the company should be operated and defining interest. Interest means आपस में, between themselves. Shareholders' rights and obligations. Shareholders agreement. Okay. You see the last line. Okay. Such agreements do not become a regulation of the company in the way of provisions of the articles. So Indian courts have held, if there is going to be difference between the articles of association and the provisions of shareholders agreement, articles will prevail, not shareholders agreement. This is one question in this. Then the specimen agreement clearly says, for example, one party is A, other party is B, and yet another common party is the company XYZ company. Now, whereas you just see they hereby agree to jointly manage the company, they become equity partners. It's not merely directors. It's not a question of directors. They are going to be equity partners. They are going to contribute capital also. And the company has been agreed to join this and then agree to these conditions. Then they will say, if you see there, what are things they can do. Okay, you take for example point number 4 in page 262. Since somebody raised this question, I thought that let me explain this. See, there shall be no further issue of capital without the consent of both parties. That means these parties have agreed to contribute and they will not bring any more person. That is another thing. Again, point number 5, if you see, board of directors, who will be there? Only A and B. And A shall have what right, B shall have what right, all those things are given. So shareholders agreement is nothing but shareholders enter into an agreement on one side of the one part and the company of the other part, telling that this is what we will be running this company because we are contributing for this company. That is shareholders agreement in short. Then you come to very important aspect, appeals concept. Okay. If you see so far, drafting, pleading, appearances, I told you that is the order. Appearances, as I told you, court craft, you wear your uniform, all those things. Compounding of offense, consent order, last, unconnected to any of these things, that also we covered. Drafting, as I told you, so far we have covered various laws. Whenever you get theory question, write first about under which law it is covered. What do you mean by that? Now I am giving you one more hint. In your examination when you are writing, it is quite possible, suddenly you just forget. You feel blank. You don't know how to proceed. Okay, you started writing mortgage. Mortgage means you write 3-4 lines, then you are stuck up. Very easy way to bring back your memory. When you prepare in this manner always. Any topic, in any law, what is it about? Because it is law, it is why is the provision? Then how is it to be implemented? If not, what? For example, you write this mortgage. What is a mortgage? Why mortgage? How mortgage is created? Types of mortgage. Like that you prepare. In examination, if you start writing, you have written what and why, then you forget. You don't know how to proceed, you are stuck up now. Simply close your eyes for a minute and then recollect. You have written what, you have written why. So naturally next will be the question of how and other things only. So prepare the subject like that. Now here also if you see, first we have done drafting. In drafting, what is drafting? Drafting means there is no law. Overall we are supposed to do like this. Parties put their intentions. Why drafting? Because unless it is in writing, then tomorrow there may be disputes. The court also cannot interpret. How drafting? As I told you, there is no law, title, all those things I told you. You do that. Now drafting is over. Pleading, appearance is over. Now we come to pleading. When we come to pleading, in your old study 7, right now I am going to start with this. In your new study 9, lesson 9, right to legal representation. Whatever given in the study, you do only that. First thing, common point in this, there is always a right to legal representation for everybody. Okay? If no vakil is prepared, even the party can represent himself. But as far as CS professional is concerned, he can represent only in up to tribunals, but not in courts. This is the second aspect. Then, how to prepare this particular little bit, 10 pages, very easy. Take one paper, one sheet is enough. Write the act name and then write to whom, before whom we can represent. There is a second column, before Competition Commission, before Income Tax commissioner, whatever it is. Then the third column is within how many days this representation must be done. Fourth column, in case of appeal, before whom I can go on appeal. Fifth column, within how many days appeal can be performed. Please friends, first column you will have Companies Act, TRI, SEBI Act, competition. There are only four. First column. Second column, who is the first authority. Third column, within how many days. Fourth column, who is the appellate authority. Fifth column, within how many days. That's all for this particular first few portion. It will take 15 minutes for you after you finish this course. Even right now you can do it. So before exam you will not have the tension how to do all those things. Make a chart. When you put everything in writing, you will remember it better. This is number one. Then in your old study 7, there is something called petitions applications. That is called pleading. Putting it in legal terms, it is called pleading. Pleading means I plead before the court. I submit before the court. Okay, this is my problem. And the other party submits before the court. That may be his problem, but I am not responsible. That is the other one. So here what happens? How do you draft? The first thing you have to understand is the word plaint is used in civil law, and in criminal law it is called complaint. In civil law, when we do not go up to court, we call it petition. In response, we call it whatever you call it as response, whichever you can give, written statement, anything. Now, here there is something given there, petitions and written statements. It's very, very important concept. You take page 270 in old and 285 in new. In examination, you got this question many times. Fundamental rules of pleadings. That is contained in Rule 6 ka matlab Order 6, R2 ka matlab Rule 2. Order 6, Rule 2 of CPC. Now, why I am particularly telling this is, with regard to drafting, there is no particular law as to how it should be drafted. But with regard to pleading, there is a method. There is a rule. There is an order given by the Act itself. We follow this pattern. What is the pattern? In petition, I am supposed to give, but I am using the word petition, not plaint. Petition because for our course, as CS, we will be going up to tribunals. I give all the facts. First, how it is written, before whom I go in the tribunal of whatever it is. Then party names. First, I give my name, and then I give the other party's name. Then, once I give that name, I am going to give them what are my problems. When I give my problems, I don't straight away go into problem. I start from the beginning as if that I am a company doing this. I am introducing myself. And he is also doing that. I supplied goods to him. He has not paid, or he has paid partly, whatever it is. So step by step I do. Then I go to the court. With regard to prayer, I want this. By prayer I mean what is the relief I want. Now if you see there, this is in short about plaint. In plaint there are some basic principles you have to understand. It is always given point wise. I must write point number 1. We both went to that place. Number 2, we both entered into an agreement. Number 3, like that 1, 2, 3, 4, 5, 6. Why is it necessary? When the plaint or petition is given to the authorities, they send a copy to the other party for the other party's reply. That reply is called written statement. WRITTEN statement, written statement. Reply of the other party to the petition is called the written statement. The written statement also should be drafted in a particular manner. What is the manner? He has to reply to each and every point. Please remember, if any point in the petition is not replied, it will be taken as if that point has been admitted. So if you want to reject or if you want to oppose it, you have to say not admitted. Not admitted, you have to make it very clear. Point wise. Point number 1, admitted. Point number 2, we both went to Allahabad on such and such a point number 1, admitted. We both entered into contract on the day, admitted. As per the contract, I have to supply goods to him, admitted. As per the contract, he has to pay me money and he has not paid, not admitted. The money has been paid. There you come to the point. The next point, it should always be facts. No question of quoting law, no question of giving evidence. Telling that key, I will not write in the petition, I will support it with these documents. No need. What is my problem? Tell that. What documents I am going to give, they are all later stages. So first similarly the other party also will give only that. When the other party gives the reply, which is called written statement, now I too have an option. What is the option? I can also find out some faults in the written statement and say no, I don't agree to what he said. That is called rejoinder. Plaint or petition, first step from me. From the other party, the step is written statement. In response, rejoinder. But there is no further response. There is no rejoinder to rejoinder, you must remember that. Rejoinder, it is over, that's all. Now here, from exam point of view, one thing is asked many times. You take page 272 in old syllabus. Okay. And forms of defense. 288 in new syllabus. Body of the written statement are forms of defense. You got theory questions on this many times. Now what happens? I am making an allegation against you. Now what you can do? First you say outright you refuse. I don't accept. All whatever he said is wrong. That is called traverse. In traverse you totally reject it. Then second you call it as confession and avoidance or special defense. There what happens? I have given 8 allegations. You accepted 5. You reject 3. Part acceptance and part denial is called special defense or confession. Total denial is called traverse. Part is called confession avoidance or special defense. Then sometimes you may object. For example, I give the petition after limitation period. When the limitation period is over, then I got no right to move the tribunal or court. So your defense will be simply point of law. As per limitation act, it must be within 3 years, but he has come after 4 years. Matter over. That is another type of defense. And the last is called dilatory pleas. Dilatory means delaying tactics. One by one, this is not there, that is not there. So forms of defense is very important. Then how to draft written statement, as I told you already, remember these concepts. Then in this, if you go further, after rejoinder there is something called drafting of affidavit in evidence important consideration. That point is important. Okay. It is page 317 or something, the new, and old me 276. Now why important is, I will tell you this. Heading gives some other meaning, but it actually tells that whenever I give the initial document, petition, then subsequently I am going to give evidence in what? I have to, evidence ka various steps kya hai? In executive you would have studied about Indian Evidence Act 1872. According to that, evidence may be direct evidence or indirect evidence. If I bring the witness himself directly, produced before the court, that is direct evidence. But somebody has seen something, he tells somebody else, and that the third party is brought into the court. That is called indirect evidence. That is not admitted in court. Something called hearsay evidence. Not that much admitted. Direct evidence must be oral. In that, if you see point number 7, page 276, old May, last point, उसमें भी होगा. That drafting of affidavit in evidence में last point जो है, that says that there is a principle from exam point of view I am telling. That is called best evidence principle. What is best evidence principle? There are various kinds of evidences. Oral evidence, documentary evidence, circumstantial evidence, hearsay evidence. There are various kinds of evidences. Each type of evidence has got certain value. I'll give a simple example. I produce a promissory note given by you, and I tell the court, this person has not made the payment. But you tell the court, I am telling you, sir, Sachi mein I have made the payment. He is telling orally, I am giving document. Which will have value? Document. As simple as that. So each type of evidence has got certain value. Now what is point number 7? You can even write down by the side, it is called best evidence principle. It means whenever any particular type of evidence is to be produced, the party should produce the best possible evidence. If he produces any lesser type of evidence, he will get only lesser value. So this is the point which is very important to understand in this particular concept. Then we come to rules of, that is next chapter, study 8, appeals. What में study 8 appeals है, इसमें it is also study 8 pleadings में appeal आता है. Now appeal में 2-3 things you have to understand. Appeal is not an inherent right. I can't go and claim that I got a right to appeal. It must be provided in the law. If law provides, there is appeal. If not, there is no appeal possible. This is number one. Then, when we draft the appeal, 2-3 things important we have to understand. First, to which court we go? Top, in capital letters. Then we write parties. When we write parties, we have to mention that in the first case, before appealing the original, what was I? For example, I was plaintiff, now I am appellant. In the original case, I was defendant, now I am appellant, whatever it is. So, in original suit, there are always two possibilities, plaintiff and defendant, or petitioner and the opposite party. This is what it is. But in the case of appeal, always the parties are referred as appellant and respondent. Please remember, the word respondent is used only in appeals. So, plaintiff, defendant, appellant, respondent. So, what was my status in the original? That also must be considered. For example, if I say, I am the appellant now, what was I? Originally, I was plaintiff. I must make a mention that. Then in all those things you can see, any appeal, may it please the Honorable Chief Justice of the High Court and of His Lordship Companion Justices. What does it mean? Now, I do not know before which court, before which judge it will go. I can't choose. So I am going to the Honorable Chief Justice and I am telling him, I am placing it before you. You or whoever is going to hear this petition, please. So therefore, I suggest memorize this one. When in appeal, you have to memorize this. May it please the Honorable Chief Justice of High Court of whatever court you are giving and His Lordship Companion Judges. Then again the appellant company most respectfully show. That is, wants to show ko, show it what you saw. Then all those things. In appeal, what we do? Remember, 3 parts of appeal always. The first part is giving the facts. The top part is which court, civil or criminal. Then appeal number. Remember, even in examination, you will not fill up the regular civil appeal number. Number will be filled by the court, not you. So that has to be left blank. Then in the matter of first one party versus again another party, there what was in the original, then may it please connect bar. First part will be giving the facts. The second part will be grounds of appeal. These were the facts. But why did I come on appeal? I came on appeal because the lower court did not apply its mind. Nothing wrong in mentioning because I lost the case. I won't write he is a fool. I need not write, I should not write. But I write the judgment has been wrong. Mind has not been applied, vagera vagera. Then the last will be the prayer. What is the relief I want? In appeal, the prayer is always the key. The original relation is set aside. Appeal is allowed. Like that is the thing. This is the main thing with regard to appeal. Then, if you see, there is something called review revision. Somebody also asked this doubt. One of the students asked this doubt also. What is the difference between review revision? In CPC, there are 3 concepts. Reference, review, revision. Reference is section 113. Review is section 114. Revision is section 115. 3 things. Very easy to remember. How to remember, I will tell you the method. See, for example, the lower court is stuck up with something. I do not know how to proceed this particular interpretation. What is it? I don't know. Or one of the parties applies to the lower court. Please, I want interpretation from High Court. So, the subordinate court refers to High Court for opinion. When the opinion is given, that opinion is followed. That is called reference. Review. A particular court has given a decision against me. I am called aggrieved party. So now what I do? I go to the very same court. I give some new evidences which I could not have given. Mark the words, the law uses the word which I could not have given. Assume that it was available, I could have given, there is no review. So, which I could not have given, now I go and give to the same court to reconsider the decision. That is called review. Revision, the High Court on its own or one of the parties applies to High Court, please revise the decision because the decision is wrong. Then High Court revises or High Court asks the lower court to revise. How do you remember? Reference is from subordinate to High Court. Like this. Review is always same court. Like this. Revision is High Court to subordinate court. Like this. So remember this. The only point you have to understand is revision need not be only in High Court, it can be anywhere. Another point, whether it is revision or review. If I have gone on appeal already, revision and review will not take place. They will say, you put it in appeal, don't bring it here. This is the thing with regard to reference, review, revision. Then, one concept is called writs. That is also there in your syllabus. Writ. Now, what is this writ? First you have to understand, just 5 minutes I will tell you about writ, types of writs and all. There is a difference between suit and writ. Suit means in a civil matter I go to court by way of my grievance. That is suit. What is writ? In writ, what happens? The aggrieved person moves only 2 courts, either High Court or Supreme Court. High Court under Article 226, Supreme Court under Article 32. He moves the court for immediate decision. Follow this carefully, for immediate decision. Please, I want immediate because it's something urgent. This is writ. Then, another thing you have to understand is that only for fundamental rights we go to Supreme Court. Okay? High Court we go for fundamental rights as well as other rights. We go to High Court. So these are the 2 differences you have to understand. In writs there are 5 kinds of writs. The first one is known as habeas corpus. Okay? Second one is known as mandamus. Third one is prohibition. Fourth one is certiorari. Fifth one is quo warrant. In brief, what are they? Whenever any person is missing, somebody comes and takes the person away. I don't know where is he. In such case, what happens? I go to the court, apply, please ask the authority to produce the person. So habeas corpus means to produce the body. Remember, even though it means to produce the body, it is not dead body. To produce the body alive, the person alive. That is habeas corpus. Mandamus. Mandamus means order to do. That means whenever any subordinate authority or tribunal does not do something which it has to do, I go to the authority and ask them to have it done. Then the third one is prohibition. It is the reverse of that. Whenever any subordinate court should not do something, it has done. During the proceedings, I know that I go to this High Court or Supreme Court, ask them to stop it. So where someone has to do, remember it's not private party, government, which as per law you have to do. If you don't do, mandamus. Where you are not supposed to do but you do, it is prohibition. Certiorari is after the decision comes, I come to know that the lower court has done something which they should not have done. I go for certiorari to reverse the decision. Fifth one is quo warranto. Quo warranto means to show the authority. Under what authority you are doing this? This must be shown. That is called quo warranto. So these are the 5 kinds of writs, and writs can be only before High Court or Supreme Court. Supreme Court Article 32 only fundamental rights. High Court Article 226 either fundamental right or other rights. Okay. Then with regard to old, we almost finished. In new, there are a few things where easy things I am not covering them. For example, will. With regard to will, see for example, e-contracts you must be knowing, you must have studied. Promissory notes also is quite simple. With regard to will, I will give you some 2-3 points. It is only for new syllabus, but still in old also, if a question is asked, you can't say it is not in syllabus. There is no provision to write that answer. So try to get it. Will में क्या है? First, Indian Succession Act, 1925. That's the law. Second, with regard to Registration Act, will is optionally restored. Then number 3, a will can be revoked. What do you mean by revocation? Whatever will I have written in the past, when assuming that A dies today, A has written 250 wills, the last will be effective automatically. Because once I write a will, the previous will is automatically revoked. This is the third aspect. So optional registration, what are the laws, and revocation. And in will, it can be registered or it can be kept for safe custody. Nothing wrong. This is another aspect. Then in will there is something called privileged will that can even be oral. This is for soldiers and others. It can even be oral. They can even deviate certain provisions, that is accepted. Unprivileged will is what we do it, other things. Then families gift. With regard to gift, with regard to gift, the law is Transfer of Property Act 1882. And gift can be of movable property or immovable property. The parties are known as donor or donee. And the most important with regard to gift is, the gift is valid only when it is accepted by the donee during the lifetime of the donor. Please follow this. The gift is valid only if it is accepted by the donee during the lifetime of the donor. I will give one case that has been asked. Very peculiar case. A gives a gift of immovable property to B. B goes for registration. Now A comes and says, I am not interested in the gift anymore, I want to withdraw the gift, don't register. Can the registrar refuse to register? This is the question. As I told you, first paragraph will be facts of the case. Second, applicable law. Applicable law will be two things: Transfer of Property Act and Registration Act. You will read both, the relevant provisions. Then what is law? The answer is, once the gift is accepted during the lifetime of the donor, it concludes. In this case, whether the gift is accepted or not, how do you know? The moment the donee goes to the registrar for registration, that means he has made that implied acceptance. So you have to add there, acceptance can be express or implied. It is an implied acceptance. He has accepted, therefore registrar has to register. As per Registration Act 1908, registrar can refuse only if to him it appears that the parties are minors or insane, or when the party says my signature is forged. Otherwise, the registrar has to register. That should be your answer. So that is with regard to gift. Then other things are quite simple. FIR वगैरह वगैरह, bail and other things. In bail theory question में there is one possibility. Bail means release from police custody to personal custody on bail bond. Somebody gives a bond of this much of money. But just because I execute a bail bond for somebody, if that person runs away, police will not catch me and put me in jail unless I helped him and abetted him in running away. It only means the money I given is gone. I have to take care that he does not run away. And bail may, there is something called bailable offence, non-bailable offence. Bailable offence is something bail is ordinarily granted. Non-bailable, it is not so ordinarily granted. And most important, I saw one question also in your paper, anticipatory bail can. You have to understand, anticipatory bail can be granted only by Sessions Court or High Court. That's what it is. Then the other aspect. Other aspect of anticipatory bail is that it is in anticipation of my likelihood of being arrested. For something which I have not committed, I can apply for anticipatory bail. This is the main thing with regard to bail. We will cover the question answers now. Then, in the meantime, I'll just relieve myself for a few minutes. Okay? Yes.
Sir, we have queries also, receiving queries from students. So I will pass on the queries to you.
You give me the queries. Some of them I might have attended.
Yes.
Some of them due to paucity of time I may not attend. Okay? But I will leave my number and email ID with you. You can always contact me. See, for example, as I told you in the beginning, whenever the question is, whenever there is a question of distinguish between, it should be between common things. Written statement, affidavit kind distinction, if you see, what is common in this, both are in writing. But as I told you, written statement is the reply given by the defendant to the plaintiff. That is written statement. What is affidavit? Affidavit is I am affirming to certain things. For example, for everything I need not go to court. Instead, I give an affidavit that I am called deponent. Remember, the person giving the affidavit is called deponent. DEPONANT. Like power of attorney, affidavit also given in first person. I, so and so, son of so and so, hereby solemnly affirm. 1, 2, 3, 4, 5. करके again I say that yes, I confirm that whatever I given above is true, and then I sign. That is called affidavit. So what is the difference? Affidavit is whatever I want to say. For example, I have paid my income tax dues properly. To the hearing I have to produce this. I give the affidavit. The moment I give the affidavit, I bind myself for the statement. If the statement is wrong, I am liable for punishment. In written statement, it need not be so. Second, written statement come meaning. The meaning is reply to plaint. Here the meaning is totally different. In exam also, whenever you get a question on distinguish between, you start like this, meaning mein what is the difference? Uske implementation mein what is the difference? As I told you, what, why, how, when, har ek mein what is the difference you do it. Then, hypothecation agreement is nothing but, as I told you, that pledge hypothecation. I already gave you the theoretical aspect. Hypothecation is something I keep the property myself and then borrow money from you. The agreement should state this, that this is the agreement, what will come first. So and so is the person who is going to give me money. I am going to borrow. You will not come, it will be only the third party. I am just giving as a reference. One party is going to borrow and is going to hypothecate what? Hypothecation of only movable property, not immovable property. Hypothecate what? What are the conditions? That in case the money is not paid, you got every right to take back the possession. And because generally hypothecation is a commercial contract, we will go for arbitration clause also. Then, one compounding of offence we already covered. Major difference of drafting of deed and drafting of agreement, nothing. Agreement is something which is the first step. When it becomes enforceable by law, it becomes a contract or deed. So as such, technically there is no difference. Drafting of deed and agreement. Because what is deed? Deed is any document which is enforceable by law. Agreement also, when everything is proper, legal, that is, for example, contract fulfill kar diya, competence of parties, no coercion, no undue influence, वगैरह वगैरह, it becomes a deed. Then, covenant and undertaking, there is no difference. Both convey this. It is like emphasizing on point. I undertake. There is nothing wrong. Everything perfect. If there is something wrong, I am binding myself liable. That is called some sort of undertaking or covenant. Shareholders agreement, you have done it. Review revision, I told you just now. This question is big question. I will go while drafting. Do you have to assume full details and all? Now, in drafting of agreements, when you write party's name, you assume some party's name. Don't leave it blank. That is between blank, son of blank. Then your agreement will be only blank totally. So put some assumption. Maybe if you want, at the end you can write note. The assumed names have been used. That's all. Only one thing which you should not fill up is, as I told you in appeal. Appeal number you will not fill up because that is given by the court. Then, see, if it is not appeal and other things, you can do any other format also. But generally, if you see, no, according to the format given is better. For example, I want to change the format, let us say. Agreement between, first I am writing the buyer's name, then seller's name. Then agreement number first, I write the first point, house has to be delivered. Fifth point, consideration. Nothing wrong. But it doesn't be much of us. So try to follow that format I told you. First heading, then in capital this deed of this thing, executed act, place name, on, all those things, follow the same pattern. You will find it as a sort of story. Literally, between whom, in which place, who are those parties, what will be referred, what is the consideration, what does he agree to, what does he agree to, and who has signed. That comes a better one. Non-testamentary. Testamentary means that which is going to be applicable later on. Will. A will is a testamentary document. That you say the person who writes the will is called a testator. And if a person dies without writing a will, he has died intestate. Sorry, one second. What is non-testamentary? Any document, any deed which becomes enforceable immediately is called non-testamentary. Like sale deed, mortgage deed, gift deed, anything other than will is non-testamentary. Okay? Loan syndication. Now what happens? There is a question of joint borrowers, joint lenders. If many people join To give loan to a single party, we call it loan syndication. Okay, many people join. It is joint lenders. For example, Delhi Metro wants 2,000 crores loan. One bank may not give. Many banks join and then give. That is called loan syndication. About this, you would have studied in security law already. Okay. Very good question. Can you file appeal against the order of award of arbitrator? No. Remember, with regard to arbitration, against the award, appeal is not possible. We can only apply to court under section 34 of Arbitration Conciliation Act 1996 to set aside the award. It is only to set aside. No appeal. No appeal is maybe because, it's not a legal reason, maybe because it is the parties who have chosen the arbitrators. So when the parties have knowingly chosen somebody, if he has given a decision which is not acceptable to them, sorry, the law will not do anything. But if the decision is illegal, which cannot be enforced in law, I can apply for setting aside. See, under testatum clause, testatum is only one line. Now this deed witnessed, that's all testatum. First you understand this. The rest is only operative part. How many terms and conditions? As I told you, your question may be for 6 or 7 marks. Already you have written the top portions. You have written the recitals. You have written the testatum. You are going through the testimony. So operative part, give the important points. As I told you in study, for example, there may be some 15-16 points. You can't give all of them. First of all, it's not possible. We won't be able to remember. Give those relevant important points. You know, one basic principle of law, answering law paper is write all that is relevant and only that is relevant. Remember that always. So write relevant things, that will be good actually. In addition also, there may be some queries you may have. I will give you my phone number. You may note it down. Now I will tell a bit slowly. 9811 456 920. 9811 456 920. This is my mobile number. My email address is, my name is S. Narayanan. So S N A R A Y A N A N at the rate of, sorry, S. Narayanan 254 at the rate of gmail.com. Okay? S N A, to start again, S N A R A Y A N A N 254 at the rate of gmail.com. So please feel free to contact me anytime. I will try to reply immediately or within a day or two. Absolutely, you will not have any problem. Just go through it carefully, understand the concept. Once you know the concept of law, around 70 marks you can comfortably answer. Even in this drafting paper, try to adopt the format and then the legal part. Wherever you make assumptions, you write the note at the below, assume assumption 1, assumption 2, nothing wrong. All the best for you. God bless you always.
Thank you, sir. Thank you so much for taking such a short span of time. You are covering all the entire study material with regard to old and new syllabus. As in the beginning I told you, all the students who has missed out this session, it will be uploaded on the YouTube shortly. And if they have any queries, as Mr. Narayanan has already given his number and email ID, you can send queries to his mail ID and he will be replied to it. And students, we are also informing you, as I told in the beginning, tomorrow also we have webcast on company law, which will be 10 a.m. onwards, and webcast on tax laws and practice, which will be 2 p.m. onwards. And in between we will have a special session on exam related queries, so you can join with us tomorrow. And all the best for your exams.
I want to add only one thing. In the beginning I went very fast because I was not sure how we would be completing. Very sorry for that. Okay? All the best for you. God bless you all.